Today, we are going to talk about the title of the presentation is From Viral to Vulnerable, How to Protect Your Brand from Dupes. So dupes have become like the new buzzword. I don't know if the word dupes existed before 2025, but it certainly exists now. And it's really an interesting conversation in the intellectual property world because the question of whether a quote unquote dupe, well, for what is a dupe? That definition is loose. But then even if something is a dupe, does it rise to the level of infringement and can it be dealt with? And quite frankly, the wall is a little bit open right now. There's a lot of cases pending, but a lot of sort of questions about what might be allowable and what might cross that line. And even Eric and I, before the presentation today, we're having some conversations about it, and we have some different views on it ourselves, even internally. So we'll kind of go back and forth with some of those different views here today, give you different perspectives on this issue. For those of you that have been here before, you know the spiel. If you're new, welcome. A quick thing about our firm. We are actually celebrating our 18-year anniversary, quickly closing in on the 2-decade mark, which is hard to believe. It means I'm getting old, but the firm has 7 lawyers. We're actually all spread out a little bit on the East Coast, but all on the East Coast, and 4 paralegals. By the numbers, we've registered over 10,000 trademarks in the U.S. in the 18 years we've been in business. We do a lot of what I call pre-litigation enforcement and dispute settling. So we've had over 1,500 cases settle without any kind of significant litigation, which is a point of pride for us because litigation typically means a lot of uncertainty and cost for clients. Right now, we have over 11,000 trademarks worldwide under our management that we manage for clients. And in 2025 alone, we registered registered 725 trademarks in the United States. So just to give you an idea, we are an all trademark firm. That's all we do is clear, register, manage trademarks for clients. So getting into what we're going to talk about today, just to give you a little bit of a roadmap. First thing we're going to talk about is just this rise of dupe culture and sort of what it has meant in the marketplace. Talk a little bit about proactive protection and what that looks like for clients, and then the core protection that you can get if you're going to try to fight back from dupes, which is mostly we're going to talk about trademarks. That's what our firm does, but we will touch on the copyright and patent element that can be looked at too for protection for clients. The next thing we'll go into is the idea of how to monitor and enforce against dupes. Some of the risks that might, from failing to do anything included in that conversation. And then perhaps the funnest part is we're going to go over all the recent dupe cases that have made the news. There's been some really interesting lawsuits that have been filed in the last 6 months. And Eric and I are going to kind of give you differing views on what we think of the lawsuits. Because in some cases, I think they're great cases and Eric thinks they're not. And that will just be fun. So it's unfortunate, Eric, we're not like in an actual like ring. It would be like in a ring or something, I feel like, for that section of things. But so stay tuned to the end is what we're trying to say.
There's nothing I like better than telling Josh he's wrong. So it's going to be, I think, a good one now. And I think that's kind of the key with all of this is that we're talking about the rise of dupe culture. And I think that it's always been some degree. It has gotten to the point where it has become kind of a, almost a pop culture social phenomenon, but we have been looking at this for years and years, back from when the first supermarket brand was Mountain Lightning instead of Mountain Dew. There's kind of been that history of people using similar looking packaging in order to sell similar products, and it's always that question of, well, how close can we get? Well, I think that now, or at least in the last, I'd say 5 years or so, we have seen an enormous uptick in not just the, hey, how close can I get, but in the, let me take what this is and blow it up to astronomical proportions so that it's almost people who are looking for the dupes. There's entire industries based on this. And I think that that's where we're going to spend a lot of our time of talking, not just how close can you get, but also just what are the bigger issues of how brands can react to folks who are not only trying to get as close as possible, but are trying to actually do what they can to ride the coattails in a way that wouldn't be allowed under IP law. One of the questions is, what is a dupe? Someone just asked, is this a legal term of art? It's a phrase for duplicate. Sometimes you might, it's hard because even just Josh and I talking about it, we might have different names for it. You might call it a knockoff, but it's not necessarily, is it a counterfeit? No, no one, are people thinking this is belongs to the product? It's usually a cheaper version, but not always a cheaper version. It's the brand name, and then the other one that looks just like it. And so we're going to use that phrase dupe a lot, but that's kind of the more recent terminology that we have seen. That's not a legal term of art, but is more of a pop culture term. Um, we've seen a lot of things in the news, like it was huge. The last slide was all about the social media uh, craze of the Walmart Birkin bag. And then, sorry, I keep going back and forth. I'm throwing Lacey off.
Uh,
Yeah, that the Hermes owns a trademark registration in the shape of this bag, but Walmart or someone associated with Walmart started selling an $80 bag that looked very similar in some ways, some would argue, to a very, very expensive bag. And the question for all of that was, what exactly is legal? Would people think this is somehow related to this very expensive bag? And we don't know. And the answer is going to be there was no official lawsuit. We're not sure if there was a cease and desist letter, but it is now sold out and has not been restocked. And so I think we can say, Josh, that certainly with some conversations happening behind the scenes. I would be shocked if there weren't some either phone calls or letters that were traded between the two organizations saying, this is a problem. But never, if to my knowledge, nothing that ever got put out to the public.
yeah, I don't think there was ever a lawsuit filed there.
And this is kind of this idea of people who have acknowledged that something is that they have purchased a dupe, meaning whatever they consider a dupe to be. That and it's a very high number of folks. So in cosmetics, you're looking at almost 20%, skincare 20%, fragrances. I was talking to Josh that I'm certainly among this. I have some sunscreen that I bought from Trader Joe's that my wife informed me is a dupe of the whatever brand because one of these websites or social media things said, hey, it does the same thing, and it kind of the packaging is kind of the same color, and that's exactly the kind of stuff we're going to be talking about. So if you ever bought something that was the quote unquote cheaper unofficial version of an expensive cosmetic or expensive footwear, handbags, apparel, anything like that, you may have bought a dupe, and you maybe didn't even know you did. But that is something that they did a pretty good survey of about a year ago that said that a pretty significant amount of folks have in fact purchased these kind of look-alike dupe products.
Yeah, that's on purpose too, right? Like looking for the cheaper version of something and trying to find it and buy it. So as a brand owner, if I'm someone the brand, I would have concern about that because that could literally be a quarter of my revenue walking out the door because somebody's making a knockoff, whatever the term of art you want to use, knockoff or dupe product, and that's successful enough and can be sold at scale because you could sell these things on Amazon and other places that really you might not have been able to do, 20 years ago. So it kind of gives the dupes have a bigger platform than they've ever had before, given the way commerce works. And it's not just, you can go to CVS or wherever, to buy or Sephora to buy your cosmetics. You can actually go on Amazon and find the dupe, if you will.
I think it's a
So
good point. I've seen this in the chat. How is this different from a generic? And I think that there is, to me at least, a generic is a product that is the same underlying product, but does not look like the packaging or the presentation. It does not take the aesthetics of the item that we are attempting to dupe. If it is we provide sunscreen and it is the same exact formula and it is a, completely different packaging, that's not what we're talking about. Even though it might be the generic version, it might not have a brand on it, it might be CVS brand. If it doesn't look like certain elements of the original in a way that's attempting to either ride the coattails of that person or from a consumer perspective, let them know that it's somehow similar to this other product, then that's what we're talking about in this, of the idea of a combination. And Josh, I'm sure is about to jump right into this, so I'll steal his thunder. It's a combination of a bunch of different types of IP law that could be potentially implicated when we're talking about dupes, because competition, fine. I don't think that anyone should argue that we should be anti-competitive and people should just be trying to stop good competitors from competing in the marketplace, but they can't use protectable elements of intellectual property to do that. And then the question is, what's protectable? And I think part of that is for every single brand needs to know what could be protectable. And that's, I think, what the next part of the presentation is going to be about.
Yeah, no, all good points, Eric. And I think that that's, that line is between generic products and dupes is also one that I don't think has a legal definition. I think there's things that blur the line even in that world too. So, all very interesting. That's where we get into in the back end of the presentation, some of the cases, and I think those examples are really interesting. So one of the things that we do talk to clients about is if they are concerned that their product is getting popular enough that you're going to see dupes start to appear, is that there are certain things you could try to register from an intellectual property perspective to fight back if somebody flies too close to the sun. And again, that definition of what's too close versus what's not is going to be the hardest thing to define. But the one thing you can at least do is get ready, and you can register different forms of IP so that if there is an obvious infringement, when you submit a takedown notice to a platform or you go and file a federal lawsuit, you have registered intellectual property rights, whether that's trademark, patent, or copyright, that when you're enforcing it gives you the ability to walk into court with essentially the upper hand when you have a registration, as opposed to if you have unregistered rights, then it can be a lot harder to enforce, especially on like a platform like an Amazon, where if something's not registered, they really don't pay much attention to whatever right you're claiming to have. So getting ready and getting filings made early is going to be something that we counsel a lot of clients on. And it can be a tough conversation because as companies are growing, there is sometimes an inclination not to overspend on legal or spend any money on legal. And sometimes you need to have a budget for these things. So the three types of IP are always going to be trademarks, copyright, and typically when we're talking about protecting against dupes, not just patents, but design patents in particular. So, trademarks are going to cover, and we'll go through each one of these. You can kind of see we have this chart here, but the first one we're going to talk about is sort of trademark protection. And the idea here is that you not only want to register trademarks in the United States, but you need to think about registering trademarks around the world, because trademarks are jurisdictional in nature. A registration in the US is not enforceable in the UK. It's not enforceable in Australia. It's not enforceable in China. So when you're thinking about registering trademarks, it's not just a US conversation. It's where is this product actually being sold right now, if it's being sold cross-border, or where are other jurisdictions it's likely to be sold in the near future. Now, this is going to be the first one. It's obvious. I won't spend much time on it, but getting names registered and logos is step one. And actually be surprised. There's a lot of companies that start to operate and don't get their name and logo registered, and then have a lot of problems when the dupes arise, because the dupes may be flying really close to the sun, especially with a really similar name. And that might be an obvious infringement, but because there's no registration on the name, again, the takedown with Amazon doesn't work, or they're having a difficult time getting any traction in the marketplace with actual enforcement. So this is kind of table stakes stuff, and seems obvious, but you would be surprised how many clients actually overlook it.
Yeah, there'll be some examples later where I think that in some of the lawsuits that were filed, that the actual packaging itself didn't look that similar, but the names did, and it was a dupe product. And I think that's where the names can still help immensely. It's we had one, Josh, in the cosmetic space against a large retailer who the packaging, it was clearly meant to be a dupe of our client's cosmetic product. And the packaging didn't look that close. They got pretty far away, but the name they chose was very similar to the name of the actual product. And that's where, again, it was they disagreed, but they did change it. And so a lot of that is kind of just that extra protection in place that says, well, I've got at least this protected. And I think that the name itself, I think, is always where you're going to start, because that's what the most recognizable thing for most brands.
Yeah, and how everybody searches to find the brand, typically once they're aware of it too. So got to have that protected. The more non-traditional trademarks that can really help with dupes too are this idea of trade dress. And in trademark law, trade dress has to be a distinctive design element, but also not functional. Because if the design was functional in any way, that's when it actually becomes a design patent. So the two examples here are the Red Bull can design, which you can see they've got this design registration on. And then this is, for those familiar, it's actually an Uncrustable. It's registered by this J.M. Smucker company, and it's the design of their peanut butter and jelly sandwich that has become wildly popular, and also subject to a lawsuit that we'll talk about later. But Trader Joe's knocked that off. So long story short, you can, if you've got this really unique product design or you've got a unique packaging design, those are things that can actually be registered as trade dress. Something that should really be looked at, especially if you're going to be dealing with dupes. Here's the product packaging one. So we've got, you can see these are actual registrations, right? We've got the Hershey syrup packaging, and really what they're getting at there is that distinctive red oval with the big Hershey's block lettering. You can imagine another chocolate product coming out with that, with a big red oval and a name in there that might not be Hershey's. Well, is that going to be an infringement? That's what they're going to probably try to argue. And you can see here we've got the second one is I believe that's a Chanel box. We've got an Adidas shoe box, and then of course we all love some Oreos, right? Which this will also be subject to a lawsuit we talk about later. So trade dress, just the look and feel of your packaging, that's something we can actually register. And another thing that's actually protectable in some cases, although this is a harder one to get, is going to be color. Under the shoe, the bottom of the Louis Vuitton shoes, not that Eric or I own any of these, but if I saw someone walking around in a red sole shoe, I'm only because I'm a trademark attorney would I actually know it's a Louis Vuitton or Louis, however you say it, shoe. Otherwise, I might not think much of it. But then, of course, you have the Tiffany blue is also a registered trademark. So if you're colors, that's one that's kind of like you have to have a certain level of notoriety in order to get that registered. Very hard to get a color registered in any real protection. If we're talking the best type of protection for the dupes is certainly going to be the trade dress, which is the packaging and the product design. Those are the things that tend to be mimicked the most. And also these are, again, this kind of comes along with names, but slogans. One of the things you'll see in dupe packaging is sometimes they'll try to use some slogans that might sound like a really well-known one. You could take and people try to get away with crazy stuff. You could see just this chart on the right-hand side shows you all the oppositions that Nike has filed against people that are doing some kind of play on Just Do It. Now, some of them might be doing it on purpose, some of them might not. But you can kind of see all the variations of their logo that people have actually filed trademarks on, let alone tried to use. So now, obviously Nike, that's a really well-known brand. This happens at the dupe level, just at a different, and maybe people not trying to register it, but certainly use, similar slogans and taglines. So getting those registered is something that's highly recommended.
And so in addition to trademarks, if you think about trademarks as your brand, when consumers see it, would they instantly think of it as being you're belonging to a particular brand as opposed to just being like nice looking packaging or something like that? Copyrights are actually protecting the creative expression. I know that sometimes when we think of advertising, we don't always think of creative expression, but when you look at a label, a lot of creative design goes into these labels, and if it reaches a kind of very minimum threshold of creativity, then certainly label artwork, illustrations, different instruction manuals, things like that. Some patterns, if they're distinctive enough, can be subject to copyright law, and copyrights are much more narrow than a trademark. A trademark is designed to prevent consumer confusion and to build a brand. Copyrights are meant to protect the unauthorized copying. So not does it look kind of similar, is it a substantially similar, which is a legal term of art, but is it basically a copy of it? And if it's inspired by, it's probably not copyright infringement. But if it is taking certain design elements and reusing them in a way that is unauthorized, then it could be something that is subject to copyright law, which is great because there is a mechanism for online marketplaces called the DMCA, which is a takedown notice procedure that every online marketplace must follow in order to avoid the infringement to be responsible for the infringement of their users. And so they all do it, and it's low cost, it's quick, but it is very kind of narrow to when actual copies are being made. If you find a dupe where they've changed it enough and they're only, like in our case, where they're only really using the name and some color schemes, we're not going to claim copyright protection on that because it's really not a copyright infringement. It is a potentially trade dress infringement, potentially design patent infringement, but copyrights are very specific to creative works. And so might be a more narrow use, but when you can use them, they're very effective because universally every platform will acknowledge, at least in the US, copyright takedown notices. You don't need to register it. It's good if you do, if you have particularly high value copyright registrations. That's kind of probably a different presentation, but that's generally what copyrights are used for as compared to trademarks and trade dress.
Get you the next slide. There you go.
Yeah, and patents, just to kind of redirect one thing you said, Josh, about when something is functional, then the only way to protect the function of something is through a utility patent. So we're going to be talking about design patents. If you're trying to protect the way something works, because it is a particular I'm making this up, a particular shade of color that makes your eye do a certain thing and it's a brand new thing. No one's ever done this shade of color before. I'm not sure if that's even patentable, but that's the kind of thing that we're talking about with utility patents. But there's a special kind of patent called a design patent that is purely for the aesthetics of something, that it still can't protect the functional way that it works, but it will protect almost more like a copyright. It does not need to have consumer recognition. You don't have to show that consumers, when they see it, they think of a particular brand. You only have to show that someone copied a design that you submitted as a design patent that has never been done before. And so the idea is that the patent office looks at whether something is novel, meaning that it is in the ordinary, I forget the actual phrase, but would someone who is skilled in the art and think that this is just a normal way to do something? And if not, is it ever been done before? Is it novel? And so if it has never been done before in that way, you can potentially own that exact way of how it looks within that patent. It's, again, a narrow protection in so much as it protects only that particular configuration. But it's not like trademarks where you're about talking about consumer confusion. None of that applies to design patents. It is about whether the design patent was copied, whether it was infringed on. And those are also ones that, if you can get it, extremely powerful, very useful for going to Amazon and saying, this person copied my design patent. Here's the evidence, take it down. And they will honor that in a very kind of, or a more predictable way. I should say very predictable, because Amazon's never very predictable, but it does help. And those are kind of, I think mostly what we're going to be talking about is on the trademark side, like Josh said, but there's multiple tools in the tool belt. And I think all of these are going to end up being things that a company should be considering early on in the process of product development, of when they have something they feel like is going to make a big splash in the marketplace.
Yeah, no, for sure. One question that I think we can take, Eric, in the Q&A that came up is, how are you protecting trade dress in the early days of a product? And the thing about it is that certain elements of trademark protection can become stronger as a product becomes more well known in the marketplace. But if a trademark is truly unique, it can be protectable from day one, meaning that the minute you file a trademark application, you're getting a federal priority date in the United States. And one of the things that we counsel clients on is, if they're like, hey, if someone came to us and was like, hey, I'm designing packaging and I want it to be protectable. Like, the idea is, then don't just, let me go back to the one slide with Hershey, because I think like Hershey's is not that unique, but they've been using that forever. So they have a little bit of extra, ability to protect that. But the idea is, like, can you come up with a design for your packaging that's truly unique, that can stand out in the marketplace? Because if you can, now you have much more, you can get some protectable elements to that packaging that if somebody else copies or comes close enough to that a consumer might think it's the same, now you might be able to complain about it. And so that would be my advice, is that, any trademark's protectable from day one if it's unique enough. And I think that a lot of companies struggle with the if it's unique enough part. I see so many, you can look online, you can see products that have really nice, clean packaging. Maybe there's a line around the outside with a nice font with the name. That's not that unique, right? That's going to be pretty hard to protect. So the next guy that comes along with a line around it and a nice font, if they're duping you, you're going to have a hard time arguing that's trade dress infringement, because a court's going to look at it and say, well, there's 100 other products with a nice line around the box and the name in a font, right? So the more unique you can make the packaging, then arguably the more protectable it's going to be from day one.
And there's a big marketing balancing act that we're doing between marketing and legal in this one, because the cost to make, for example, custom molds for containers is far exceeds the cost of just going on a catalog and saying, I like that shape and give me that one. But everyone else has access to that same catalog, and no amount of money you're going to put in is going to say, well, now I'm the only one who gets to use this one. It would take a huge capital investment in a custom mold to get a specific packaging that you would then be very incentivized to protect. And so sometimes it might not just be worth it in the early days if you don't even know if the product is going to be viable in the marketplace. And so it's going to be a balancing act. I don't think that there is a lot of the times I would say that the most protectable, legally protectable trademarks are just jumbles of letters because no one wants to use them. There's no reason for someone to use them. If you want to use packaging that does fit in, with the other packaging that's out there and is modern looking and all this kind of stuff, there might be some trade-offs. And I think that's where dupes really come from also, is this, desire to compete, but you have a reference point. And the reference point usually is not the strongest from a legal perspective, because it could be infringement, or it could be something that's just kind of generic packaging. And so it's definitely a balancing act that I see a lot of folks dealing with. And counseling clients early on that act and knowing what the risk kind of is for them and kind of letting them know that early is, I think, exactly what the attorneys on the call should be thinking about, because the earlier you can inform them what the options are, the better.
Yeah. And we've had plenty of clients, I feel like, come to us and be like, oh, I have this bottle shape and someone took it. And we're like, well, where did you get the bottle from? They're like, well, from the catalog that everybody gets bottle shapes. Like, well,
right. This looks exactly like my bottle. It's like, well, yeah, that's the bottle shape. And right. It looked exactly like it. I was like, oh man, they're copying. And then I realized that, that's a very common shape in this one particular industry, and no one, had the rights. And it was I'm sure a frustrating conversation, but it helped at least, them start to think about, okay, well, what else can we add to this, to our label to make it ours compared to our competitors? And I think, that's great.
So the artwork comes in. Yeah. Right. Yeah, for sure. So talking a little bit about monitoring and enforcement, the idea that, okay, we've got all these filings made, and now, typically we need to start to monitor the marketplace. Typically clients will come to you once they see things. That's pretty common anymore. But also there can be really this idea that things start to exist and clients that invest in, there's all sorts of different monitoring tools that are out there, but with the vast nature of the platforms between Amazon, Alibaba, and all the others, Walmart now, having a way to look for lookalike products and places you might be getting duped, and getting on top of that early can be important. One of the things that is just a practical tip in any kind of enforcement is that if you get to someone before they get traction, then typically you might have a better reaction when you send a demand letter, or maybe the platform, you might be able to get it taken down before it really gets any kind of significant traction. So sometimes easier to deal with things before they become big. And that's just where the monitoring can really be helpful. Places that we see and tools that can be used. The first is, and first and foremost, this goes for any kind of trademark monitoring as well, is everybody that owns a trademark registration should be monitoring the USPTO database for similar filings that get made. This is Mainly for a couple of reasons, but one is that a lot of trademark filings get made before a product launches in preparation for a product launch. So if you see a filing get made and they haven't launched yet, you can get in touch with the person and say, hey, wait a second, I see you made this filing. I'm going to have a problem with this. And that a good amount of the time when you reach out to someone early enough, they have more flexibility to make a change. So if they know they're going to be walking into a legal problem, they might make a change. So the earlier you can get to somebody, especially if they're letting you know in advance by making a trademark filing, the better. Um,
I'll say it's
you
also
know,
great ways to, if you find someone who is using a name that's not similar to yours, but their packaging looks similar to yours, it's a great way to find contact information. It's a public database, and you will be able to get their attorney or their information to reach out. So even if it's not directly something that it's certainly a great resource.
yeah, for sure. Google Alerts, another good. I mean, I have a Google Alert set up on my name. I have it set up on the firm name. That those are all good ways to identify, especially if someone's trying to use comparative advertising with the dupe, because sometimes they'll be like, this is just like whatever, the brand name. So if you're monitoring, Google with the alerts and even social media has ways of doing that, looking for your brand name being used. Because you'll even see, on social media, you might see people sharing and be like, this is a great dupe of whatever product, a Chanel product or whatever it is. And if you're monitoring that and have a way of identifying that, you might be able to find the dupes a little quicker that way too.
And call me a cynic, but I also think that a lot of the online engagement about the kind of social media influencers who that's their whole thing is they're finding dupes. I would be very shocked to find out that they did not get reached out by some of these companies and for paid advertising.
Oh,
Or
sure.
something like, hey, here's my product. It's a dupe of this. And then, they're trying to get their own followers. So I think that you're going to know your industry well, but that's something to always just be checking up on. That it's more rare, I think, than not that something comes up completely organically without at least some push, especially if it's going to make the company a lot of money.
Yeah. And then the other thing is that there are a lot of vendors out there that have software tools that help you do the monitoring, whether it's on social or on websites. We name a few here. There's not recommendations, but there's a lot of different tools out there that you can research and find to use. The biggest concern that we have as a law firm with these tools is that sometimes they will also take the step of sending takedown notices. And that is arguably a legal decision to send a takedown notice and legal work. And if you do send takedown notices using these platforms and they're incorrect, then that can open the client up to liability. We've covered that in a previous CLE. So we always say use those as, in our view, they should be used as information gathering tools. They're great. There's great, software tools out there that can help because there's so much information online to search through. So that's just another way to monitor.
Yeah, in the chat we also had someone, are there any recommended services? There's some that are looking for um, yeah, online enforcement. I think those are the ones that are particularly dangerous. There are some that are just monitoring the USPTO website. We offer a service that does that. There's other ones. There's some platforms that you can do it yourself. We are early adopters of a website called TMTKO, and I'll put it in the chat. They're great, but it's also just data, and the data is then how you use it, and configuring it and all that kind of stuff. But yeah, I think that that's generally something that if you use something like Core Search, that's another one that you can have kind of monitoring reports sent to you each month for different parameters. I don't have any particularly other, we use both of those, but in different instances. But that's kind of hard to do for what we're talking about today. Very hard to do for like trade dress filings and things like that because
Yeah.
they're so specific and weird. And I do a monitoring where I look at every trademark trade dress because I'm just a trademark nerd and I like looking at them, and occasionally I'll post about them, but not something usually that's very easy to do monitoring on. It's more about just kind of paying attention to the marketplace.
Yeah. And ultimately, when it comes to enforcement, it's the usual suspects. You could start with a cease and desist letter, especially if you have good contact information, and start trying to get conversations started. Takedown notices in today's world, that's a very popular one. Again, through whatever platform is being used to sell the product. And of course, you have litigation, which we'll talk about in a minute, and that's going to be the most expensive option, but arguably the one that might have the most impact if you're struggling on options 1 and 2 here. But I feel like we've seen, we've had clients, on both sides of this fence. I've had clients that have gotten demand letters and decided I'd rather not get sued because the cost of litigation is going to be really high. So and they'll agree to phase out of whatever, packaging they're using, even if we think they have a good defense. And on the flip side, we have people who are enforcing for, and, we'll get responses to demand letters, the typical, we don't agree, but, we'll agree to, phase this out or stop doing this. And so they can have their effect, and they can be good. It just depends on who's on the other side and how concerned they are you're actually going to file litigation, which is arguably one of the reasons you should, in serious cases, litigate, so that people know and they can look at the litigation record of the company and know that they do litigate. And because we've had a client, I even had a client ask me, he's like, well, has this company sued anybody for Dupe products yet? When we were evaluating some packaging, and we went and looked at litigation history of a company to try to understand, how litigious are they? Because these are all very practical things that will be considered, in addition to the legal side of things. So.
And I think if we've kind of made it clear so far, and if not, we will when we get into the kind of specific lawsuits that have been filed, that this is an extremely fact-specific gray area, and that is the worst place to litigate when you don't have a firm answer at the end that's where cease and desist letters get to be very effective. Negotiation, and it does become this thing that the more you've proactively protected, the more you can show, here's what our track record looks like, the easier it's going to be to get a person to do the math to say, all right, the risk level's too high for me. And I think that's all it is. It's about accepting risk and not accepting risk. And so if you can kind of make that pressure gauge go up and say, well, this is going to be very expensive for all of us, but if it does come down to it, we're going to go to the mat. That's where all these tools really help. Litigation is just unbelievably expensive, and I think we all know that. And as a result, we all act accordingly, because I don't think there is a bright line rule 99% of the time when it comes to these dupes, because small changes on every single package, or the way that it's marketed, or the way that the company talks about it, is going to make a huge difference in the outcome. And as a result, I think everyone needs to be very kind of aware of what the situation is.
Yep, absolutely. No, that's great. I don't know if you want to take this slide, Eric.
Yeah, I mean, failure to protect it means that you're going to lose that kind of distinctiveness. It's trademarks, and especially trade dress, are about consumers recognizing it as a brand. And so when it becomes just a trope, or if it becomes just another design element that everyone uses, no one owns it. And you can try to put the genie back in the bottle, but that's going to be very difficult to do after the fact. It's going to be something that once you have 100 people all using it, then that's largely sailed. So you're going to end up losing distinctiveness in that kind of thing, and it's just going to be financially just not that financial equation flips when you realize how much work you have to do if you haven't started from the beginning.
We'll take a little bit of a breath here. We're about to get into the main event, which we've been hyping the whole time, Eric, which is the recent cases in the news. We haven't had a lot of questions come in. We got about 20 minutes left. So if you have questions, there's a question and answer tab that you can go into, and feel free. We'll try to get to them, as many as we can here, but just feel free.
I think this is a good pausing point also to say that we are lawyers. We are not your lawyers or these lawyers that are involved in any of these cases. And so Josh and I will talk very candidly about what our opinions are, but we don't even have all the information. So there's no way we could give our legal opinion on any of these. But I think that we can talk through kind of the pros and cons of a number of these cases that have come up, because I think it'll show kind of why there's not a clear answer, and why the winner is usually the one with either the most conviction or the most money. But a lot of the times it ends up being that no one's a winner. It settles, and we don't know what the outcome was or how they settled it. So a lot of stuff happening behind closed doors, and we can only guess at, and there's not a ton of things that go to trial because of how uncertain. No one wants to go before a jury and have them decide, because that's going to be, the very
Conflict.
difficult.
Yeah. Great job on the disclaimer there, Eric. We can
Yeah, no problem.
our
You know, I,
liability carriers will be very happy with you. So
you're welcome. That's a different webinar, but and then also we'll get to the CLE words, and then also Lacey had shared the written materials too. We'll make sure that we have that as well. Share with the chat again, just so you have a copy of this presentation.
So the first case, which I kind of teased a little earlier, is this Uncrustable case. Smucker's sued Trader Joe's, saying it copied the design of their sandwiches because Trader Joe's is offering also a circular peanut butter and jelly sandwich. The complaint talked about the crimping on the sides that you see there on the boxes. They're both crimped on the sides. They're both circles. They're both kind of puffy sandwiches with peanut butter and jelly in them. Trader Joe's calls there's the crustless peanut butter strawberry jam sandwich, which is a pretty generic name. Obviously, Smucker's has the Uncrustable brand. Eric, what do you think of this one?
Yeah, no, I think that this kind of goes to what I think the channels of trade are here, is that in order to buy a crustless peanut butter and strawberry jam sandwich, which I myself have purchased, and we're big Trader Joe family fans, but you have to buy it from Trader Joe's. You have to walk into the store and buy them. It's going to say Trader Joe's on the packaging, and to my knowledge, you can't buy these one-to-one. You can't take these out of the packaging and resell them to other people, at least not like legally. And so that the only way people would come across this product is with full knowledge of where it came from, and that it's not related to the Uncrustables, which I believe is a strong brand. It doesn't use that word, use the word crustless, which is descriptive. And yeah, no one in my family at least would say that the crimping on that, they would say that, well, that's just how you make it. How else would you make a crustless thing without just slamming those two things together? And so I think this one is one I think is with what we have, very just off the dome. I think this one's a harder argument to make, given that the packaging looks nothing like the Smucker's packaging, and the word Uncrustables is nowhere to be seen, even in a reference.
So this is where I have a slightly different view of this one. And I should have had this graph, but Target made another sandwich like this, and Target's is square, and it has less of the crimping looks a little different. So there's definitely a different way you could make this, right? You don't have to use a circle. You didn't have to use that exact crimping pattern, and Smuckers, to their extent, went ahead and registered that shape and that crimping pattern. So what are the chances that I'm at a friend's house and I don't see the Trader Joe's packaging, they throw me one of the sandwiches and I think it's an Uncrustable and I eat it and I think it's horrible because it's Trader Joe's version of it and it's no good. Now, I've never tried it, so I don't know. But then I could have what we call post sale confusion, in the sense that I thought it was an Uncrustable. Now I think Uncrustables are disgusting and I don't buy them again. So I do think that, hey, look, there was a different way for Trader Joe's to make this product. They didn't have to use a circle. They could have used a different crimping pattern. Why did they have to copy Smucker's? I don't know. I mean, obviously, I think I know why they did it, but I would argue infringement. And that's what I know Smucker's is doing. So, but that's how you can see there's two sides of this fence. So, Eric strongly disagrees with me.
No. I think it's a great point, because I think that it does go down to, and I think a good point of whether it tastes bad or good, it doesn't matter. It's because Smucker's doesn't have control over it. So that's what their concern is that this idea that people are going to get something. I think on the other end of that, you get into this idea, well, does Smucker's care because they have a competitor, or do they care because of the potential for confusion? Yeah, that I think is a harder question to ask, because I think that's where it may be something to say, well, I can keep my competitors further away from me, even if there's not really a branding issue here. But yeah, I definitely, there are points that we made. This is not a frivolous case. I think that there's some that we can look at and say, like, you guys, none of them here are ones that I think are frivolous. I think that they're all good cases. There's just some that I would say there's at least some things that they're not slam dunks.
Right. No, I think that's all. And that's, look, I mean, I'm sure Trader Joe's attorneys will make some of those arguments. Here's an interesting one. So we actually have Surfside, which is a upstart company. And Anheuser-Busch comes in, which is obviously the big gorilla in the room, and makes this Skimmers product that you see on the right. That's an Anheuser-Busch product. And Surfside sues Anheuser-Busch saying, no, you stole too much from us. This looks too much like our Surfside can. And also, yeah, I mean, I think that was the case. It was really the look at the design elements, with the shaded lines at the bottom of the can, the sun in the middle, uh, and then the top as well. And that was the kind of the main point in the case. What do you think about this one, Eric? Does Surfside have a case?
See, this is I mean, I would have to see more marketing to say I think this is a tough one that you, the elements to this one kind of you can describe it as like, well, it's inspired by it clearly was intended to look like it or to service the same folks, but there's a lot of elements here that are very different, at least from the side to side comparison. I haven't dug into this one, but yeah, I would also be curious how many other companies are using Sun's skimmer and it has a bird on it. This one I think is also a tough one for those purposes, but it also is a much bigger company that could very well bury a smaller startup. And so that's also, I think, what we go into some of the strategy conversations of, well, we got to do something because this is potentially existential, even if it's not
Yeah.
a great case of trade dress.
Yeah. I mean, I agree. I mean, I think this is a tough one for Surfside, because at trial there's going to be a lot of differences in these cans. I think I'm very aggravated if I'm Surfside because I'm like,
Yeah.
they clearly didn't need to use the gradiated lines at the bottom of the can, right? I mean, that's an element that I think is like, why are you using that? You know what I mean? There could be a million other things they could have used down there. The idea that it's lemonade and you have a light, yellow theme, the ours or the surf side, it's not ours. The surf side, it looks like a lemon with the sun. The other one looks more like just the sun. So I don't know about that element, but definitely the bottom of the can. And then you start looking at the rest of it and you're like, well, clearly they got that from somewhere, right? And I don't know. I come back to I have a problem with dupes because I'm just like I think it shows a lack of creativity from the company that's doing the duping. I'm like, why not just go out and make your own product, make it really great and compete, but don't compete on the same look and feel as the existing brand that made the market. And in this case, Anheuser-Busch obviously seems to have taken a page from Surfside's book. The question is, ironically, are they too close to the sun?
Oh yeah,
Um,
there we go. I was going to say, but the same argument could be made about consumer comparative advertising, though. That you could say, well, why do they need to use our name in there? And it's as part of it is to help the
well,
consumer know what they're getting. And if that
yeah,
can be done in a way that doesn't violate IP, then and it helps the consumer find a product and skip all the discovery aspect of coming up with a new brand. Yeah, I think that's always been a part of the marketing strategy. But from a legal perspective, I completely agree. I think that that's where we as lawyers and the marketing folks are going to forever have a battle because I think that we want two different things.
yeah, yeah, for sure. All right, this one is next up. We got Deckers versus Costco. Deckers makes the famous UGG boots, and they have that unique design around the ankle there that you can see. The original UGG is at the top. The Costco version's at the bottom. What do you think on this one?
That's tough. Just because it's clearly meant to look like it. It is meant to be but Costco is also known for doing that as well, as far as
Yeah,
kind of just the Kirkland brand, that we kind of have chatted about that. That is a very distinctive house brand, but it also does have at least a history and lore of it being very related to existing brands, and so would consumers think this was the cheaper Costco version of Uggs? I could see an argument. I think informed consumers wouldn't, but trademark law is not about the informed consumer. It's about the relevant consumer. And so you might get someone that says, we already have Uggs at home and that it's, the Costco brand and, they might not get the real thing and there might be some confusion there. I could at least see an argument here.
yeah. I mean, it's a pretty unique design around the ankle of a shoe, it's like why, again, why couldn't you come up with a different? You're obviously using that design for a reason.
And
So
as Ruthie in the chat said, there's about 1,000 brands that have knocked off this shoe. So I think
yeah,
that
I know.
that
Yeah,
likely goes into that.
yeah,
The thing we said before, what happens if you don't enforce it
yep,
effectively? And the answer is, can you target just one of them? And Costco will certainly argue if they didn't that everyone else is doing this. Consumers are not going to be confused.
yep, yep, 100%, 100%. I've made that argument to opposing counsel. Um, Another one, Costco in the hot seat here. Lululemon suit them. This is a little harder to see in the slide, but basically the lines on the Lululemon, if you're familiar with Lululemon, they have certain lines in their clothing, and Costco was accused of copying the lines in the clothing, Eric. Um, I don't know if you or I are real big Lululemon people, so I don't know how much we know about
Well,
that.
I mean,
Oh, okay.
Lululemons, but for as far as just like men's pants go, they're just very normal men's
Learn
athletic
something new
pants.
every day.
So as
Yeah.
far as lines on shirts, yeah, I think it's going to go into this idea of consumer confusion. Looking at surveys, looking at that kind of stuff. I think there's going to be two ends of this argument, and one is the one that I like is that you have to also realize where people are going to be buying these, and it's not going to be this careful inspection of the product, or if they see it out in the wild, it's going to be potentially someone who's just kind of jogging past, and if they're like, oh wow, that's a bad fit, and they think
Mm-hmm.
it's a Lululemon, then yeah, that's going to be a problem. But I think at the same, there's only so many ways you can make clothes in order for it to have some of the functional benefits that a lot of these athletic companies want to be using, that might, make it so that certain parts of the shoulders look stronger, all that kind of stuff. So I think it's going to be very fact specific for something like this as to, what's out there.
Yeah. Well, you have to go to Costco and buy the Lululemon pants and tell me if they're as comfortable.
I mean, I love the chat right now because we're getting the exact argument you and I are having, Josh, in just both sides of people saying, well, no,
Yeah.
there's no brand name on there. So it's not. So I think that's great just because we're all acting as consumers too, of saying, well, I don't see it. I mean, I think this one is one where the word mark does a lot of work of
Yeah.
nerds and dweebs. This was a one that they filed a trademark application for too, and I
Yeah.
believe were opposed. And so I think this one's this one's a little egregious. I think if I got my son Dweebs, I think he'd be a little upset. I mean, unless they're good, but if he was expecting nerds and got Dweebs, I think that's not the most to your point, Josh, creative elements.
Right. No, I mean, I think that's like one where you're like, all right, like, it's like you said, flying close to the sun. If the name is different here, maybe you get away with that packaging at some level, but with the name and the way it's even written, yeah, that's going to be tough. That's going to be real tough.
I think that these are good, and especially this one's a multi one. This is
Yeah,
a
this one I like. I mean, you look, Mondelez makes all these snacks everybody knows, right? You got Oreos, Wheat Thins, Nutter Butters, Chips Ahoy, and you go to Aldi, you see all the ones on the right hand side. So they were like, "Hey, what the heck?" And they sued them. What do you think about this? Is this just a generic store brand, or is this more rising the level of trademark infringement?
Yeah, I mean, the problem with something like Aldi is that they do the same thing that Trader Joe's. I mean, they were split off from Trader Joe's back in the day, and so they're very much of this two sides of the same coin. They're known for this, and so I think
Yeah.
that you would kind of end up with like the snake eating itself kind of argument of, well, we did this, but we've always done this. We do this. Is this now a problem? Yeah, and I think that they are skilled in getting it to look as close as possible and kind of testing the waters with things and seeing what they can get away with. I think some of them are more egregious than others. I think that the thin mint area wheat thins and thin wheats. I think that one's original. They both
Well,
would
the
be
name gets you
original.
in trouble, I think, right?
Yeah, that's
Yeah.
close.
Yeah.
Certainly with the word original in big letters, every time they
Yeah.
use that, I'm like, well, they're not the original, that's for sure.
Thin wheat original,
Um,
not the wheat thin
I
original.
think
Yeah.
golden round crackers, I think that one's probably fine. I don't think anyone may make very compelling. It's just the color red that's really
Yeah.
distinctive there. So yeah, I think that there's certainly some stuff that's close, and they've made a whole business out of trying to sell those kind of
Right.
look-alike products, store brand type products at a cheaper price, and yeah, certainly successful in some, and in some are, I think, they've gotten letters about this, and obviously they've gotten a
Yeah.
lawsuit.
I hate the business model. Again, I think I like the fact that Mondelez is going after this. Look, Mondelez has made how many probably hundreds of millions of dollars investment in these brands, and Aldi's going and trying to just sell these things. I don't know. I mean, I get the strategy, but I also think that, Aldi has an opportunity to make their own version of these products where they don't have to look like the national brand. Like you said, I think in some cases, some of these are going to probably, pass mustard because they're far enough away. And then other ones, you got too many elements that are the same. So it'll be interesting to see if this case actually makes it to trial. It might get a mixed verdict on it. So that could be interesting. Gonna have to skip through the rest of this stuff. You can see it all when you download the materials. There's a few other examples in there, but cases continue to get filed, and something we'll continue to monitor and talk about because it's really interesting. But that puts us at time, everyone. I really appreciate you joining us today. That went really fast. Eric, we must have been super interesting because time flew for me. I don't know about for you, but
Nah, anytime I can spend arguing with you, Josh, it's time
yeah,
well spent and goes by quickly.
yeah, that was fun. Maybe we'll be trending on TikTok later today. Who knows? Just kidding. We don't even know how to post this on TikTok. So, well, if you have any questions about this, please feel free to email Eric or I. You can see our emails. We're always happy to take questions. Feel free to reach out. Follow us on LinkedIn. Check out gerbenlaw.com for we got a blog there that talks about anything that's in the news. You can kind of follow along there as well.